Next to argue is Charles McCloud on behalf of the respondents, Roberto Felix Jr. and the County of Harris, Texas.
Thank you, Mr. Chief Justice, and may it please the Court. When an officer doing his duty confronts a threat to his safety or the safety of others, it is reasonable for that officer to use force to end that threat. That's the conclusion this Court has consistently reached, and that's what the Fifth Circuit correctly held below. At the moment Sergeant Felix used force, he was clinging to the side of a fleeing suspect's car, and Felix reasonably believed that his life was in imminent danger. That conclusion should end this case.
Yes, in general, an officer has a reasonable authority to use force in response to a threat to his safety. But does that include when it is the officer who put himself in danger?
Petitioner's contrary argument attacks straw man. Let me be very clear. We are defending the decision below and the moment of threat doctrine as it actually exists. The core premise of that doctrine is that an officer doesn't lose his right to defend himself just because he made a mistake at an earlier point in time.
In this case, the straw man is not being presented by the petitioners, but by the respondents. It was never a question of whether or not Officer Felix made a mistake, but whether or not he put himself in danger and used that as an excuse to execute a suspect he was investigating. Yes, execute. But of the facts I've found so far, no one has been able to determine if Mr. Barnes' actions were malicious or merely accidental. Was Mr. Barnes attempting to evade paying tolls that he had accrued to the rental car before he rented it? Or was it a simple mishap where he attempted to get out of the car at the officer's request, but failed to put the vehicle in park? We'll probably never know.
But applying that rule does not require courts to ignore everything that occurred prior to the use of force. Like other circuits, the Fifth Circuit has repeatedly held that preceding events are relevant to the extent they inform the officer's perception of the danger that he faced. The panel decision below repeatedly cited to and quoted from those very precedents. The panel did not and could not overrule them sub silentio. Petitioner asked the Court to create a new breed of constitutional tort, under which an officer facing the barrel of a gun loses his right to defend himself if he previously used bad tactics or poor planning.
Again, this straw man of bad tactics or poor training is used. We're not talking about a situation where an officer parked his vehicle in the wrong place or whether or not he forgot to bring a pen with him. Officer Felix is accused of jumping onto a moving vehicle and using that as an excuse to take another man's life.
That's contrary to precedent and common sense. Graham asks only whether an officer's use of force was reasonable in the particular circumstances he faced. It requires courts to put themselves in the shoes of the officer who used force, not to second-guess every decision the officer made in some of the most stressful circumstances imaginable.
I'm not sure about precedent, but what is contrary to common sense is to believe that a law enforcement officer holds absolutely no responsibility when he or she contributes to a dangerous situation. This seems to be at the heart of Mr. McCloud's argument.
And Plumhoff and Mendez rejected similar officer-created danger theories as illogical, unwarranted, and inconsistent with precedent. The Court should reject the theory again in this case and affirm the judgment of the Court of Appeals. I welcome the Court's questions.
Under Mr. McCloud's theory, officers can create all forms of danger without any reasonable cause to do so, yet cannot be held accountable. Does that sound reasonable to you? Should an officer be able to stop you and ask you questions at gunpoint? After all, that is an officer-created danger without reason. Since the officer in that circumstance was in imminent threat of death or serious bodily harm, and the accused had not initiated or escalated the situation, wouldn't they have the right to use deadly force to protect themselves from the officer that created the dangerous situation?
How would you assess the difference between the Fifth Circuit's approach, which you as youth see it, and the totality of the circumstances approach as we heard it this morning?
So I don't think that there is any difference between what the Fifth Circuit does and what Graham directs. Both.
No, I mean as what the Solicitor General and petitioners, as they see the totality of the circumstances, not so much Graham.
So the difference, I think, between our position and somewhat the government's position is they want to include within the totality of the circumstances arguments that the officer escalated the danger or created the danger. And we think that that is now a relevant consideration under Graham and under the Fourth Amendment. In those cases, the question is, was there a legitimate threat that the officer is responding?
In other words, Mr. McCloud seems to believe that law enforcement officers should have absolute immunity for any danger to the public they create. I wonder if Mr. McCloud would still hold to that argument. If law enforcement broke down his door, entered his home in the middle of the night with weapons drawn, would he still find the officer-created danger not relevant? Much of the interactions between Mr. McCloud and the justices seem to me to be him trying to skirt around this basic fact. Mr. McCloud's position is to ensure that police do not have the same burden of reasonableness as the average citizen. After all, any citizen on the street that uses deadly force in self-defense must also show that they did not initiate or escalate the situation which led to the threat against them. Although Mr. McCloud likes to refer to the officer making a mistake, bad tactics, or poor planning, what he repeatedly pointed out in his response to the justice's questions was he did not want to consider if the officer had contributed or initiated the danger that he was in. Just look at this interchange between Mr. McCloud and Justice Sotomayor.
If your answer had been if he had walked up in an unmarked car in plain clothes with a gun drawn, and this person, and he walked up to the car and this person took off or accelerated slightly and he jumped on and shot blindly, do you think that's reasonable?
I think that would not be reasonable.
All right, so you've given the game away because at that point you have to look at what the officer did.
And, Your Honor, we agree that you can look at what the officer did, and the Fifth Circuit does look at what the officer did. The best example I can give you—
It didn't in this case.
In this case, that's because the only argument that Petitioner made below, the only action she said you should look at, was an action based on officer-created
And we have
danger.
three judges who said we shouldn't be limited in this way in the mine run of cases, and so we're stuck with this. We think the judgment is right, but it wasn't addressed at all. Officer-created danger wasn't addressed, and the other side says clearly it's not raising it here.
Did Mr. McCloud actually say that courts can look at an officer's actions, but not if the action was based on officer-created danger? Yes, he did. I guess Justice Sotomayor was correct. Mr. McCloud did give away the game.
So you can still look to things that the officer did prior to using force, but you cannot blame the officer for creating a bad situation and second-guess all of the decisions he made.
I don't believe anyone was trying to second-guess all of the decisions the officer made, only the actions of him jumping onto a moving vehicle and shooting blindly inside.